Andrew Harper's death changed British law. But now, 7 years later, two men convicted of his death could leave prison earlier than his family expected. And according to reports published today, the government believes it cannot simply stop that from happening. So how can a case become powerful enough to change the law, yet still end with the victim's family fighting for the sentence they thought had already been decided? This story begins on the evening of the 15th of August 2019. Police Constable Andrew Harper was on duty with Thames Valley Police in Berkshire. He was 28 years old and had been married to his wife Lissie for only 4 weeks. Andrew and another officer were near the end of their shift when they received a report about a stolen quad bike. They responded. What followed happened quickly. A group of young men had taken the quad bike and were attempting to escape in a car. The stolen vehicle was being pulled behind them using a long strap. As the suspects drove away, Andrew became caught in that strap. He was dragged behind the car for more than a mile and on country roads. By the time the vehicle finally stopped pulling him, Andrew had suffered fatal injuries. He had gone to work as a police officer that day. He never returned home. The investigation moved quickly because officers already had information about the car involved. Henry Long, Albert Bowers and Jessie Cole were arrested and prosecuted. But the exact legal outcome of this case matters. All three men were prosecuted for murder, but they were not convicted of murder. A jury found Bowers and Cole not guilty of murder. Long had already admitted manslaughter, and all three were ultimately convicted of manslaughter in connection with Andrew's death. Long had been driving the car. Bowers and Cole had been passengers. In 2020, Henry Long received a sentence of 16 years. Albert Bowers and Jessie Cole each received 13 years. The sentences immediately caused anger. Andrew's family believed the punishment did not reflect the seriousness of what had happened. This was not a minor accident during an ordinary drive. The men were escaping after a theft, and Andrew died while carrying out his duty as a police officer. But the jury's verdict meant the court had to sentence them for manslaughter, not murder. For Andrew's wife Lissie, the case could not simply end there. She began a campaign for a new law. Her argument was clear. When an emergency worker is unlawfully killed while protecting the public, the sentence should recognize the unique danger faced by that person. Police officers, firefighters, paramedics, and prison officers go into situations that other people are trying to escape. They respond when someone is in danger. And sometimes they place themselves directly between the public and that danger. Lissie Harper's campaign gained national support. Parliament eventually passed a change that became known as Harper's Law. The law created mandatory life sentences for people convicted of unlawfully killing an emergency worker while committing another crime, unless exceptional circumstances justify a different sentence. The change officially entered British law in 2022. Andrew's name had become part of the justice system. His death had changed what could happen in future cases. If an equivalent offense happened after Harper's Law came into force, the person responsible would normally face a life sentence. But Harper's Law did not change the sentences that had already been imposed on Long, Bowers and Cole. The offense happened in 2019. The convictions came before the new law took effect. This meant Harper's Law could protect emergency workers in future cases, but it could not go back in time and replace the sentences already given in Andrew's case. That detail has now become the center of a new national argument. Britain's prisons are under severe pressure. The government introduced changes designed to reduce overcrowding by allowing some prisoners to serve a smaller part of their sentence inside prison before completing the remaining period under supervision in the community. under those changes, Albert Bowers and Jessie Cole could become eligible to leave prison after serving half of their 13-year sentences instead of remaining inside for 2/3. Henry Long is serving a different type of sentence and is not in the same position. To be absolutely clear, Bowers and Cole have not already been released. This is about their eligibility for an earlier release under the new system. But for Andrew's family, that distinction does not remove the pain. They believed the court had imposed 13-year sentences. Now they are being told the time actually served inside prison could be shorter than they expected. Andrew's mother, Debbie Adlam, publicly opposed the possibility. His widow opposed it. Police leaders opposed it. The chief constable of Thames Valley Police said that if the men were convicted today, Harper's law would mean they received life sentences and would not be eligible for this form of early release. The Police Federation also began examining the possibility of a legal challenge. The public response grew rapidly. A petition demanding that Bowers and Cole should not receive early release collected more than 800,000 signatures. This was no longer a quiet disagreement about prison policy. It had become a national test of what a sentence is supposed to mean. Then the government said it would examine the policy again. The possibility of blocking the releases appeared to be under review. For Andrew's family and supporters, that created a small opening. There was still a chance that the rules could be changed. But today, the story took another turn. Reports from Downing Street now say the government believes it is not legally possible to create a simple exception that blocks only Bowers and Cole. The reported problem is that they were convicted of manslaughter before Harper's law existed. There was no separate offense at the time specifically covering the manslaughter of an emergency worker. Creating an exemption for these two men alone could face a legal challenge. Creating a wider ban for everyone convicted of manslaughter would affect many other prisoners whose cases involved completely different facts and different levels of responsibility. That leaves the government trapped between two difficult positions. On one side is a prison system that officials say is running out of space. If prisons become completely full, police could struggle to detain new suspects and courts could struggle to impose immediate custodial sentences. On the other side is Andrew Harper's family, who were told that the men convicted over his death would serve 13-year sentences. They then fought to change the law so another family would not experience the same sense of injustice. Now they are watching those original sentences become part of another policy designed for an entirely different problem. And this is where the case becomes more than an argument about two prisoners. It asks a much larger question. When a judge announces a sentence, what should the victim's family be able to believe? Does that sentence represent the time the offender would spend inside prison? Or can the government later change how that sentence is served because the prison system no longer has enough space? There is also an uncomfortable contradiction at the heart of this case. Andrew's death convinced Parliament that people who unlawfully kill emergency workers during another crime should normally receive life sentences. That is now the law. But the men convicted of Andrew's own death are still governed by the older system. The law carrying his name protects future emergency workers, but it cannot change what happened in his case. That does not mean Harper's law failed. The law created a permanent change that applies to new offenses. But it explains why Andrew's family can look at the current situation and feel that the protection created in his name has not protected his own sentence. The government has not said that Andrew's death was unimportant. It has not cancelled Harper's law, and it has not erased the convictions. The issue is whether Bowers and Cole can legally be excluded from a release system that applies to a wider group of prisoners. Police representatives are still considering their options. A legal challenge could ask a court to examine whether the government's decision and the way it applies the release rules are lawful. But no court has yet ruled that the men must remain inside for the longer period. There is another point that must not be lost. Andrew Harper was not only the name attached to a law or a national campaign. He was a newly married 28-year-old police officer who answered a call about a stolen quad bike. He responded because that was his job. His final decision was to help someone else. His family then spent years turning their loss into a legal change intended to protect every emergency worker who answers the next call. Now, 7 years after his death, they are being forced back into a fight they believed was over. The question is no longer whether Andrew's death changed the law. It did. The question is whether the justice system can honor that change while applying a release policy created years later. Bowers and Cole remain convicted of manslaughter. Their original sentences remain 13 years. But the amount of those sentences they could serve inside prison remains at the center of a fast-moving political and legal battle. And with more than 800,000 people supporting the campaign against their early release, this argument is not disappearing. Andrew's family changed the law once. Now they are asking whether they must fight the government to protect the meaning of the sentence that came before it. What do you believe a 13-year sentence should mean? Should a person serve the period expected when the court imposed it? Or can that period inside prison be shortened when the entire prison system is running out of space?